Welcome to the first video on my commentary channel. This will be the first video released, and it is on cost factors in the Victorian legal system. I've had to do this for school, so I thought may as well make a video out of it, because maybe other people they're doing VCE legal studies units 3-4 can come in and have a look at it and probably help them as well. Cost factors in the Victorian legal system. Other costs are aligned with the Victorian legal system. The costs are lawyer fees, fines, and court fees. Going to the magistrate's court alone can cost you from around about $2,370 for a plea to $2,821 for a bail application. These costs are quite high, and a lot of people can't pay 2.5 to 3k out of pocket and not feel a thing from it, especially if the person is already poor or homeless. So organisations such as Legal Aid step in to help these people, but they have very strict guidelines to be able to qualify for their help. The problem with legal aid not charging or charging very low prices, it leads them down a road to where need funding from the government, and VLA tends to be underfunded, and that leads to harsher guidelines and less people getting representation or legal help from, as they cannot qualify for legal aid. They're too poor to pay for legal help themselves, leading these people to having to self-represent themselves in court, which is a problem and leads to problems with all three principles of justice, as the lack of representation impacts on fairness, the right to a fair trial, and equality. With no one helping you with your case, you don't know what you're doing, you don't know what's going on, and you tend to not know what to do, and it can lead you to being up against someone with a very skilled prosecutor, and you as the defendant don't know what you're doing. So yeah, and access is the last principle that is heavily impacted by legal aid's underfunding, as some may not be able to even get the littlest help with their case. But judges are encouraged to help people who can't afford legal help and don't qualify for legal aid, therefore having to self-represent. So courts and judges must adapt to change with their process to help deal with the number of people that's rising having to self-represent. To outline the problems with self-represented parties, there was a case of an unrepresented mother and her daughter who was also a carer, and they were unable to stand their hearing. The case is called, I can't read that, it'll be on screen. I'll have it on screen then, the case. To outline, mother and daughter were charged with various charges by the Yarra Rangers because they failed to demolish their house after people came and burnt their house down on them. So they were charged for not demolishing that. The mother and daughter were self-represented and were later fined for the charges and were struck out of appeals due to them not turning up to their retrial. They sought to reinstate their claim, but it was ultimately rejected. The mother was a pensioner with a learning disability, and her daughter/carer, whose first language, might add, was not English, struggled to explain themselves to the judge and were given limited assistance. They did not fully understand the hearing or what was going on during it. So, the title of it there, table for the principles of justice. To outline this first table, if an accused person can't properly participate in a hearing, it may lead to unfair processes. In particular, the following can lead to unfairness: if a lack of familiarity with language of criminal trials, lack of knowledge of courtroom facilities, and lack of understanding of procedures can lead to a lot of unfairness in court, and not all legal representation is equal. That isn't unexperienced or cheap lawyer may result in the proceedings being unfair and the accused not being represented correctly. If parties can't afford representations, they risk not being treated as equal before the law because, well, they can't pay, they don't have anyone to help them, or they've paid for a really cheap lawyer who's not going to go all out of his way to do the whole thing. So they can be underrepresented, and, well, if that goes through that, they don't know what's going on. They will be charged with stuff. They didn't know what was going on. Don't know what they've been charged. They do probably, but yeah, they've been charged and they don't know what's going on in the courtroom. Especially if they're up against a skilled or experienced prosecutor, when they're especially if they're representing themselves, it can lead to charges being put on them that they probably could have taken away if they had the same level lawyer, but they can't afford it. So they're not going to get represented fairly. And accused who can't pay for legal representation will have trouble accessing court and mechanisms and determining criminal charges, which can lead to the person pleading guilty to a crime they may not have even committed in the first place because, well, they don't know what's going on. They think that's the easiest way to get out, but if they don't have someone to help them, well, they don't know what's going on, so they'll get charged for something they never did. Reforms can come in handy when something is in need of change in the court process. One such reform allowed victim support dogs into the courtroom to help victims of violent crimes or witnesses of crimes so that they're not as stressed out when they're doing it and they can sit on the stand longer, therefore probably saving money in the court process because it's not all dragged out long because of heaps of breaks, but all shrunk down to a lot smaller, or a lot shorter than what it would have been if the dog wasn't there. But the problem with these court dogs is they have to be raised and cared for, and training one dog alone can cost $30,000 just to train one dog to be able to go in a courtroom and help support these victims and witnesses who have got all this psychological damage and they're probably terrified out of their minds, stressed out, not knowing what's going on. It costs $30,000 to train each dog. Then in Victoria, as of the printing of the legal studies, BC 3rd, 4th units, 5th edition, there were 6 dogs in Victorian courts, and 6 times 30,000 is $180,000 just to train these dogs. Then it's about, in Australia, it's about 1.6k to train to, well, raise a dog for a year, or care for a dog throughout a year. You times that by 6, that's a further $9,762 that's being spent on caring for these dogs, plus the $180,000 that's been spent to train them. So that, just to train and care for them outright for the first year is $189,762 just to train and care for them. But then after the care's, all the training's done, you still have to pay $9,762 to care for these dogs throughout the year. So yeah, that's a lot less, and these dogs probably save more money going through the court process because they're probably saving time for costs for the accused if they've paid for a lawyer, because they don't have to take longer, meaning they have to pay the lawyer more for the whole thing. It's actually, then they can, with the money they've saved, they probably, over a few years, they've probably saved the whole $180,000. They can fund it into raising more of these dogs to help save more money, probably, and some of them, those funds could be funded into services such as legal aid, so more people can get represented by legal aid and such organisations, so they don't have to spend all their money on a lawyer or self-represent. So that's beneficial for them. A proposed reform in the Victorian court relates to cost factors actually quite closely, and that is increased funding for legal aid, legal centres, and other such services. This reform would give more money to legal aid and other legal services to allow for more equality in the legal system, essentially. And more money means more people can get represented by these organisations rather than having to self-represent. Which means their guidelines get a bit more lenient, so more people can come in. And this all came about it started in early 2017 when the Law Council of Australia conducted a massive review into the state of access in the justice system in Australia for people who experience disadvantage, e.g. people with a disability, people with economic disadvantages, Aboriginals, children, and other people, or others that all have difficulties in the legal system. one of the most important pieces of work came out of it, which was 59 recommended reforms in August of 2018. And this whole review was conducted by a former court justice of the High Court, Robert French AC. One of the recommended reforms that was made said that the Commonwealth and state and territory governments should invest a significant amount of additional resources into the legal and other services in Australia, with the minimum recommended resources given to them was $390 million per year for these legal services. The review also found that there was an undermet need and that the legal services were experiencing high levels of undermet demand, resulting in large numbers of people being turned away, which results in injustice because the lack of fair hearings. The Law Council said that it is the government's responsibility to ensure an appropriate safety net was in place for these legal services so that everyone has access to the legal help. This was recognized as public benefit to spend money in this area. In June of 2020, the Commonwealth Government announced an extra $248 million for legal services, as well as restoring the $150 million they were going to take away from them already. So the funds were being provided to various legal aid commissions as well as community legal centres. But however, there remained still a shortfall between funding given to these services and the demand for these services. So there still is a fair bit of a way to go, but hopefully we start to get there soon, and hopefully some more of these reform gets implemented soon. More funding is needed for these legal services so people can get help. Thank you for watching this video on reforms and cost factors in the Victorian legal system. If you've enjoyed this one, there aren't any other videos on this channel as of recording, so you can go check out my main channel or my Pokemon channel, or even either of my mates' channels. Well, thanks for watching or listening, whichever one works, and have a good one.